Hello, good morning, and welcome to Sunday Funday, presented to you by Courtroom Confidential, the fastest growing true crime news channel on YouTube. How are you, everyone? I hope that you are having a wonderful 4th of July weekend, or just a wonderful weekend, depending on where you are in the world. If 4th of July doesn't mean anything to you, but our family had a really good time with a little block party and ate some hot dogs and looked at some fireworks. And I hope you guys all did the same. And thank you so much for carving out some time on a Sunday morning to be here with us. So welcome, everyone. Hello to everybody who's in the chat, Zarcasm and Don Sturch and Jenny G and Black Witter. Good to see all your familiar faces. Arizona Gal, member for 3 months. So what's happening here? You're about to find out, Arizona Gal. Thank you so much for being here. And hello to everybody who's on Facebook and everyone who's on X, formerly known as Twitter. We're streaming there as well. So hi, everyone. If you're watching us from Facebook and Twitter, we would love to hear from you. So please say hi in the chat if you're able to. My name is Joshua Ritter. I am a former LA County District Attorney. I was a prosecutor for about 10 years. I left and went into private practice as a defense attorney. This is, of course, Courtroom Confidential, where we try to present to you both sides of the courtroom as best we can. And this is Sunday Funday, where we took your questions throughout the week. You left us messages. They're all incredible. We got a ton of them. And we're going to answer them live today. And we're going to answer as many of them as we possibly can. So I appreciate you, everyone around the world, for the messages that you sent in. That is what makes this show so fun, is your questions and the things that you guys come up with. It always amazes and surprises and me every week. And I'm juiced. I'm ready for today. So hit those like buttons. Please subscribe if you haven't already. Share this video with someone that you think might enjoy it. And let's go ahead and get started. Before we do, though, we thought that it wouldn't be appropriate for us to not acknowledge everyone in Texas who has been really going through a rough time, being affected by the flooding there in Texas. So our love and our prayers and our thoughts go out to you, obviously. Everybody, please stay to the end. We do have some announcements, some fun stuff I think you're going to enjoy, but let's jump into these messages because there's a bunch of them and they're good ones. And I think you guys are going to like it. So let me see if I just did that. Let me see if I just did this right to begin with, Kaylin.
Hello, Courtroom Confidential. This is Beth from Denmark. I really enjoy your shows. Yeah, I really do. And my question is regarding the Kohberger Deadline show. They are using materials that they know is under a gag order, and they are not supposed to have this information. Why are we only talking about their rights in the First Amendment? And why isn't it a crime for them to buy or whatever they got their materials to buy or whatever, gag order materials? This is Beth. I'm really happy to be here and have the rest of the Sunday a fun day. Bye-bye.
Beth, thank you so much. What a great question to kick us off with. From Denmark. Is this the first time we've had a caller from Denmark? That's so cool. Awesome. Thank you very much for adding Denmark to our map. Yeah, zoom out there for a second, Caitlin. Look at that. Look at how we are slowly taking over the world. I love it. Great question, Beth, and I appreciate you calling in. If you are a first-time caller, so good to hear from you. Your question is about the Bryan Kohberger case. Yes. This was the case out of Idaho where these 4 beautiful young people's lives were taken. Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin. And your question is about the gag order. And I like the way you put it, Beth. You know, First Amendment, I get it. I understand, right? Freedom of the press. But isn't there something illegal about all of this? And the answer is really no. because that is part of the First Amendment, and that is part of freedom of the press, is that they are allowed to do interviews, get information, have information leaked to them, pay for information. None of that is quote unquote illegal. Now, I am not a journalist, and I'm not going to get into the ethical concerns behind all of it, but I'm sure they've had their attorneys go through all of this and made their own decision. And at this point, it, is not going to have the effects on the trial that we were in fear of. But I thought it was a good opportunity to actually take a look at the dissemination order. So you guys got a, oops. Let me, hold on. I'm going to get it figured out here. So you guys got an idea of what it is that we're actually talking about. There it is. So this is the revised amended dissemination order. This is what we're calling the gag order. It's really called a non-dissemination order. This is the revised amended because there was originally an order put in place early on with the magistrate judge when he was first arraigned. They slapped a gag order on this case immediately. And then they revised it to be actually more inclusive of people involved in the case. Usually a gag order, if a judge puts that into place, has to do with the attorneys. But this one went beyond that. And you see here what it applies to. Therefore, the following is order. The prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys, defense attorneys, any attorneys representing witnesses, victims, or victims' families are prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. So anyway, in other words, everybody, prosecutors, defense attorneys, anybody that they represent, witnesses, all of those types of folks are included under this. And then it goes on to kind of thoroughly list what that means. The identity of evidence, the nature of evidence, the character of people involved in the case, the identity of witnesses, on and on and on and on. An extremely thorough non-dissemination order. But Beth from Denmark, interestingly enough, you can go through this whole thing. You'll see this was signed June 23rd of 2023 by Judge. I just want to always take the opportunity to say Judge when I can. But this was the prior to Judge Hippler, even when the case was still in Moscow. What it doesn't include is the press, because it really cannot. Had it included the media or the press, you can expect that they would have brought this immediately to court, tried to rush it in front of an appellate court to rule on the constitutional issues involved, because though the judge does have jurisdiction over all of these parties and can protect the integrity of the case, a judge cannot tell the media what they can and cannot report on. So, did Dateline do anything wrong? No. Well, did Dateline do anything illegal? No, they did not. Did Dateline do anything wrong? Well, that's a bigger kind of question. But as far as violating the law, they did not. And that's why the judge, Hippler, when he reacted to this, his reaction wasn't one of, I want Dateline hauled in here and I'm going to slap charges and contempt orders against them. It was find the leaker, because the leaker violated that order. And the leaker could be brought up on contempt charges. And Bess Nancy says unethical, maybe. It's a fine line. I know a lot of people, I was bothered by it because I thought, will this create problems? We have such an important trial, obviously a moot issue now, but such an important trial with such incredible ramifications. You don't want anything messing it up. That's why I was losing my head about them destroying the home. I thought, why are we doing this? Let's get this trial done and then worry about all of these things. So that's why I was bothered. But obviously from a just educational perspective, I think it was incredible to learn some of this information ahead of time, because of that gag order, we did know so little, and that was enlightening. By the way, more has been released since then, and I'm going to just give you a little sneak preview. Tomorrow night, Monday, Kevin Fixler and I are going to be going through all of that. We're going to talk a little bit about it more later, but Kevin Fixler and I are actually going to sit down and go through some of this recently released computer imaging of what they believe took place. Yeah, there we go. Our Monday night special, new video revealed. Kevin sent it to me, and he's like, "This is fantastic. You got to watch this." And then he even said, "Can I come on Monday and talk to everybody about it? Because I have some thoughts and I have some things that I think they may have gotten wrong in their reconstruction." But, we could talk freely about all this stuff now because we're not going to be influencing any potential jury, as you know. Lots of Bryan Kohberger case questions today. So we're going to get all into that case and the kind of fallout and ramifications. And yes, Alicia K. Mayo, you will be getting your Fixler fix. All right. Oh, what did I do? Somehow I messed it up again. All right.
Hi, Josh. This is Suzanne in Marietta, Georgia. I was wondering if you could talk about what I guess you could say, boundaries are for prepping witnesses ahead of trial, and whether they're any different for criminal cases or civil cases or prosecution or defense or plaintiffs or by jurisdiction. I was a little struck in the Karen Reed trial how when Hank Brennan would ask the defense witnesses if they had discussed their testimony with their attorneys, the attorneys for Karen Reed, he made it sound like it was really outside of bounds and really shady. And is that just an intonation thing on his part, or is it shady? So I appreciate it very much. Thank you.
Well, I appreciate you asking, Suzanne from Marietta, Georgia. We're going to put you on the map, first of all, to thank you for calling in. There we go. Great question. And this was something that more than a few of you asked about. What was going on with all of the questioning of witnesses about whether or not they had spoken to the defense? There was some questioning of prosecution witnesses about what their communications were with the prosecutor. And you asked, is this kind of just the way things work? Is it kind of a local jurisdictional thing? What's going on here? Or is it just kind of a stylistic thing? First of all, I will say that it is a tactic in cross-examination when there's a break. Like, so in other words, I would do this all the time as a prosecutor or as a defense attorney. But when you would have a witness on the stand, and let's say you go to lunch or say you have your morning break, and then that witness comes back onto the stand and you're cross-examining that person, one of the first questions out of my mouth was, during the break, did you talk to the defense attorneys in this case? Did you talk to anybody in this case? And it creates that moment in court where everybody's like, oh, is this a gotcha moment? Is Ritter going to expose something? And the witness always starts to, beads of sweat form on their brow, and they're saying, well, yes, I did. Oh, what did you talk about? And it's these kind of moments. Nothing's wrong with that. Nothing's wrong with talking to witnesses usually. And I'm gonna put that little caveat in there because we'll get to what was actually happening in Massachusetts. But usually there's absolutely nothing wrong with that. Now, the witnesses don't have attorney-client privilege, and so I'm allowed to ask about stuff like that. And sometimes it would reveal something like, yeah, they told me to make sure I mention X, Y, and Z. And you could expose some sort of bias there. I would do the same thing with my own witnesses. I would tell them during the break, I would go and talk to them and say, you're doing great. I'm going to ask about this. by the way, when you get back on the stand, the defense may ask you if you and I talked. Well, we did, and there's nothing wrong with that. And if they ask you, what did we talk about? I'm going to tell you right now what I've always told you, and that is that you should testify to the truth. And then when they would ask that question, I would have this real wonderful moment in court from the witness saying, yeah, the prosecutor told me to just make sure I tell the truth. And I could kind of look over at the jury with my, cat that caught the canary grin, and be happy with how that all played out. But I'm getting way far afield of what your question is here, Suzanne. The question is, what was happening with Karen Reed? And in that case, and I don't know if it's entirely unique to that case or if it's unique to Massachusetts, but it's certainly something that I have never seen to this extent before. There was a sequestration order in place. Many times there are. Same where I practice. We call them a motion to exclude, meaning we don't want any witnesses in court hearing, potential witnesses in court hearing the testimony of other witnesses so that it might influence them. So usually if you're going to be a witness called, you're to remain outside of the courtroom until it's your opportunity to testify. But in Massachusetts, it went farther in that they didn't want these witnesses talking to the attorneys at all. They wanted this kind of complete shutdown, sequestration of witnesses. And that is why Hank Brennan made such a big deal about it, because there was an order in place. And so every time somebody said, yeah, I spoke to the defense about such and such, he could point out, were you informed that there was a sequestration order in place? And it was, trying to have this moment in court. I think probably the best example of that was with Dr. Russell, where she talked about being in the limo with Alessi and him telling her to, always ask for a transcript. And it was this kind of gotcha moment that he had in court. But, despite all his gotcha moments, it sure didn't turn out well for poor Hank. So anyhow, great question, Suzanne from Marietta. Appreciate you. All right, let's keep it going here.
Hello, it's Ida from Gdynia in Poland, in Europe. What do you think about using an alternative pleading strategy, both not guilty and not guilty by reason of insanity, in a case like Carlos Reales Dominguez, where the evidence is strong, but the defendant has been diagnosed with schizophrenia and probably was insane, so not met the mental state which is required for criminal liability, such as intent or awareness. Should this be allowed? Now, it was a verdict after 3 weeks of deliberation, so not guilty of murder first degree, and it was hung jury for murder in second degree. It was 10 to 2 people for not guilty. So, what do you think? Hi from Gdynia, Baltic Sea. Hello, thanks.
Ida from putting Poland on the map for the first time. I love that. From Gdynia. I had to look that up. That is spelled, for everybody keeping track on your scorecards, that is Gdynia, Gdynia, Poland. Thank you, Ida, for putting Poland on the map. And thank you, Flora Paris, for the gift of a membership to someone. So whoever received that, enjoy. Best Nancy, 5 memberships. Thank you so much. Everybody enjoy. Crazy Mom memberships. I love it. Let's keep it going. Make it rain. And Stephanie says 3 months of pure joy. Looking forward to more. Well, we appreciate you, Stephanie, for all your support. All right. To Ida's question from Gdynia, Poland, asking about the Carlos Reales Dominguez case. Boy, was this case, I don't know. On the spectrum of awfulness and shocking and disturbing, it's going to be towards the high end. This is a case out of UC Davis here in California. He was a student there. And I remember when this broke, they started to have these stabbings, and 2 people had ended up dead. A 3rd person survived. And we thought that maybe we had some sort of serial killer on the loose up in that area where UC Davis is. And come to find out, it was this student, Carlos Reales Dominguez. He killed a 50-year-old gentleman named David Bro. There he is. And a 20-year-old gentleman named Karim Abu Najim. Both tragically lost their lives. And then he stabbed and attempted to kill Kimberly Gilroy, who actually was able to testify at trial. And he has no connection to these people. The defense was that he had an absolute mental breakdown and a complete snapped. I mean, no other way to put it. He snapped. He actually testified at trial, and he testified that he was suffering from schizophrenia. He apparently had been diagnosed with that. He was starting to hear voices, whispers. He was seeing shapeshifters, as he described him. He thought that these people were shapeshifters, and that he has no memory of the actual stabbings themselves. And he pled not guilty by reason of insanity. And they were actually able to present his mental state because he testified. So usually the mental state of the defendant in an NGI case doesn't become relevant until you get to the insanity phase. So it's a bifurcated trial again. You're going to have the guilt phase where they decide, did this person do it or not? And then you're going to have the insanity phase where we hear all of the mental evidence. In this case, because he testified, they were able to get in all of that mental state evidence, and then it became something different from NGI. It became an impairment defense. That's a lot of law school stuff to throw at you all at once, but here's how it breaks down. Before you get to not guilty by reason of insanity, first you can talk about somebody's mental state affecting their ability to form the requisite intent. So this is the instruction here: mental impairment defense to specific intent or mental state. So give me a second, because I'm having trouble reading that with my eyes. I'm going to pull up a larger version for me to look at here. Oh, there we go. Never mind. Great job, Kaylin. So this is the instruction here in California. This is the instruction that the jury was given. It says, you have heard evidence that the defendant may have suffered from a mental disease, defect, or disorder. You may consider this evidence only for the limited purpose of deciding whether at the time of the charged crime, the defendant acted or failed to act with the intent or mental state required for that crime. The people have the burden of proving beyond a reasonable doubt that he had the required mental state or intent, and do not consider this in deciding natural or probable consequences. So anyhow, because he testified, because they got the evidence in of him suffering from schizophrenia, from mental, what do they call them? Audio hallucinations, visual hallucinations. They were able to ask for this instruction. And the jurors felt that he didn't have the premeditation and required for malice aforethought required for first-degree murder. So he was found not guilty of first-degree murder. And in fact, for the lesser second-degree murder intent, they even weighed heavily on a not guilty on that. And so in other words, they're coming down to an idea here that this person was simply too impaired to having committed the crime. This is what's interesting about that, Ida, and I'm glad that you brought this up. He is not guilty of first-degree murder. They're going to retry him on the second-degree murder, I imagine. But he is not guilty of the first-degree murder, which is different from what would have happened had this gone to the insanity phase, where he would have been found guilty, and then, here we go, this is the insanity determination, and then decide whether or not his mental state affected his actions, and therefore, are we going to send him to prison or to a mental mental institution. You see in this instruction, it says you have found the defendant guilty of. This is post-conviction. You have found them guilty of, let's say, first-degree murder. Now you must decide whether he was legally insane when he committed the crime. To prove this, you must show that they were legally insane when they committed the crime, had a mental disease or defect, so schizophrenia, and because of that was incapable of knowing or understanding the nature and quality of their actions, incapable of knowing or understanding that their actions were morally or legally wrong. That's the insanity that we're all used to. The NGI, not guilty by reason of insanity. That's what we're all used to. This is post-conviction. So this is somebody who has been convicted of murder, and now we're just trying to decide, does this person go to prison for the rest of their life, or do they go to a mental institution? Here, it was even more than that. He was found not guilty. They cannot retry him on the murder because of that impairment defense. So really tragic case, really horrible case. And it will be retried again. And you're all wondering to yourselves, well, what if he's found completely not guilty? Well, if he's found completely not guilty, then the criminal courts are not involved anymore. And we have to then decide, are we going to put some sort of conservatorship in place because this person is just too dangerous to just walk the streets with the mental state that they're suffering from. Great. Appreciate that, Ida. I see I missed a couple of thank yous. Thank you so much, Esme Grief, for the super sticker. And to P. Lola's mom, let's make it rain. Love our CC crew mods and Josh. Appreciate you. June, thank you so much for the gift of memberships. I hope everybody enjoys those. And Forrest Nelson, thank you so much for the gift of memberships. You guys are fantastic this morning. And Farm Girl, thank you. When you're not chasing people off for your property, I appreciate that you have a time to send some memberships. And Flora Paris, thank you for the gift. You guys are all super fantastic. I appreciate you all this morning. What a great Sunday we're having so far. We've hopped around from Denmark to Georgia to Poland already. All right, where are we going next here?
Hey Josh, this is Lolly from hot and humid Virginia Beach, Virginia. Thank you for creating this Sunday Fun Day. It truly is a great time week after week. And although some stuff may be in the random knowledge category, I think we all leave just a wee bit smarter. So thank you. And with that, here's my question. We know that defendants often appeal their convictions, and in some cases, such as with the death penalty, there's an automatic appeal. But is there ever an instance to where the prosecution can appeal an acquittal or even a directed verdict? Or is the state stuck no matter what? Thanks a ton, and thank you for just being you. I hope all your todays are better than your yesterdays, and all your tomorrows are even better.
Oh, I love that cheerful salutation, Lolly. What a nice thing to say. Lolly, let's put you on the map. Virginia Beach, Virginia. You said it's humid there. I hope you're sipping on some lemonade and iced tea, keeping yourself cool. Great question. We hear about the defense appealing all the time. Does the prosecution ever have an opportunity to appeal? The short answer is no, never. That's why it is a high stakes game for the prosecution. That's why they have the burden of proof. Grizzly says, lurking while working. Hello, everyone. Hi, Gisla. Good to see you. And that's why the prosecution has the opportunity to present their case first and present a rebuttal, because they do have the burden of proof, and there is so much at stake, because if they lose, game over. Double jeopardy applies, and you get one shot at somebody. When can the prosecution appeal, though? They can appeal some things, not a conviction, but they can appeal some things. One, they can appeal pre-trial rulings, like evidentiary rulings, if they feel that the judge made a mistake in the law. So in other words, prosecution is asking for evidence to be admitted or denied. Judge makes a decision. Prosecution feels that this fundamentally affects their case and was an absolute error in the law, the way that the judge decided. They can appeal that. It's called a writ usually, and that's where they put a pause on the proceedings and they send it up to the appellate court, and we wait for an appellate judge to decide, and then they send it back down, and they either tell that judge you got it wrong, or they tell that judge that you did just fine, let's move along. Always you got to think about it. You're making quite a challenge to the judge as the prosecutor. You're saying, I'm writting you, Your Honor. I'm saying you're wrong, and I want another judge to tell you you're wrong. So if they come back and says that the judge is wrong, the judge might be chastised to some extent. And if they say that the judge was right, you better believe that judge is going to give you the eye, knowing that they got the better of you. Luciano says, hello, Josh from Marietta, Georgia. Any idea on the item that Kohberger was carrying? I'm a super fan. Thank you so much. I love that. Let's keep that question up. I want to answer the rest of Lolly's question here, but I love that question because I was wondering that same thing. So pretrial rulings. You can also, as the prosecutor, appeal post-trial rulings that deal with mistakes on sentencing. So the person's been convicted. Now we're sentencing, and the judge does something completely wrong in sentencing, ignores some sort of law that says that there's a mandatory prison time or something like that. That can be appealed. But other than that, that's why we have mistrials. That's why when there's a deadlocked jury, the judge declares a mistrial. If it's not a mistrial, then that person has been tried and double jeopardy attaches. So mistrial essentially says this trial doesn't count. This trial was something wrong took place. Therefore, double jeopardy doesn't attach, and we're going to allow you to retry that person again. So great question, Lolly from Virginia Beach. Yeah, not many opportunities for the prosecution. By the way, the defense can also make all these same appeals. They can appeal pretrial rulings, they can appeal sentencing rulings, and they can appeal the conviction altogether. A lot of deference given to the defendant. Okay, let's get back to that question about Kohberger. We'll kind of do an aside because I do like that question. It was about whether or not what he had in his hand. Do you have it there, Kaylin? There we go. Luciano Breginski, thank you so much. I have no idea what he was carrying. This is coming from the prosecutor in his kind of statement made in court, talked about how the surviving witness inside the home not only saw him dressed all in black and with a mask over his face and with the bushy eyebrows, but said that he was carrying something. And I can't remember, you guys probably remember right now, it was described in court as something like really odd. If anybody remembers what that was, please put it in the comments. But I remember discussing that with someone, and we thought to ourselves, you know what? That might just be the knife. It might, a vacuum. That's what it was. He described it as a vacuum. Yes. Thank you, Gisla. Of course you're paying attention. DM said a vacuum type object, now described as a container. That is such a bizarre one to me. And I'm trying to think, well, what is a vacuum type object? I don't know what that means. I mean, to me, if somebody's carrying a vacuum, it would be fairly obvious that they're carrying a vacuum. And I also can't imagine him carrying something around of that size. And then I thought, well, is she referring to, kind of the nozzle end of some vacuums? Could that have been the knife? And she, in her, startled state, alcohol kind of influenced state, just thought maybe that was a vacuum part that he was holding. Little car vac, perhaps somebody pointed out. I don't know. It's such a mystery, and I'm hoping I'm hoping that as information continues to come out of this case, we'll understand what that was. I was also frustrated too with that statement that the prosecutor gave. I know that we're kind of getting on an aside here, but there was nothing new in that. I mean, the only thing that stood out to me was that part about the vacuum, the part about that they said that it was a Q-tip that they recovered from the trash in Pennsylvania. And there was something else. They confirmed the 23 times that he drove by that cell tower. But other than that, it read like an opening statement where it was a bunch of stuff that we already kind of knew. What it certainly wasn't was we sat down with Bryan Kohberger and got a proffer, and here's everything we've learned. I mean, he even said there were a bunch of unknowns. We believe that he entered the home with the intent to kill. We believe these different things. I am hoping that there will be an opportunity to answer these things, if not for us, but for the families, because they deserve it, and they have come out of this whole thing with no more answers than they had going into it. So great question. All right. Let's keep it moving here.
Okay, 6 times the charm, right? Hey there, Josh and crew. This is JD from Denver, second time caller. And I meant to call in this question last week when it would have been more apropos in timing, but I didn't. I forgot. So anyway, in regards to the Kohberger case, as the defense team was, requesting a continuance, and yes, I realized we're past that. It was denied. But my question, I was curious if is there such a thing where you can ask for like a mini continuance in between? So say you go through normal timing of the full case and you do get a conviction, then can you have a continuance or extension in between that and the penalty phase? Kind of like a compromise so that you don't have to hold everybody up and stop everything for a continuance before the case, but then I'm sure you know what I mean. Anyway, is that a thing or am I just delusional? Which is very likely. Let me know because I'm very curious because it seems like it would be a great, like I said, compromise. Well, anyway, I absolutely love spending it Sunday fun days with y'all. I know this isn't probably going to get in until next week anyway, but I thought I'd shoot my shot just in case. Have a great Sunday.
Thank you, JD. JD from Denver is juiced, everybody. She's excited, and I appreciate you making the call. Alicia K. Mayo says, official congratulations to Joshua on being an official Fox News contributor. Fox knows brilliance when they see hear it. Oh, that's very sweet of you. Yes, I was recently retained as a Fox News legal contributor. You're not going to hear me doing any kind of political commentary, but if they got crimes coming up, they're gonna call me and ask me about it, and we're very, very thrilled to be involved in such a large organization like that and to have that kind of exposure. So thank you so much. Luciano says, I wouldn't be surprised if it was a tripod and he got everything on video. Oh my God. Well, if that is true, then please tell me the police know about that at this point. I know we're just kind of shooting in the dark here, but that's another thing that it possibly could be. I mean, that's the thing that's bothering me is we're not even told the size of this object that's being described. Are we talking about something 3 feet long, or are we talking about something a foot long? I don't know. It could dramatically change what we believe it might be. How about sit down and ask the guy and get some answers for these family members? Anyhow, back to JD's question from Denver, Colorado. There you are, Denver, right in the middle of America. Can you ask for a continuance between the guilt and penalty phase? So had Bryan Kohberger gone to trial and had he been convicted, that would have been part of the guilt phase. Then following that, those same 12 jurors would be asked to remain in their seats so that they could put on the penalty phase, which would be all about who is Bryan Kohberger? What is his history? Has he been a violent person? Has he been a non-violent person? Do we have people who say bad things about him? Do we have people who say good things about him? Aggravating and mitigating circumstances for the jurors to decide whether or not he should receive the death penalty. And JD's question is, well, a lot of the concern from the defense was they don't have those witnesses ready to go and prepared. Could we take it to continuance between guilt and penalty? And the answer is sure. The judge can do kind of whatever the judge wants. If the judge says to those jurors, I'm ordering you back in a week, we need to get our ducks in a row, the judge could do that. I imagine the judge doesn't want to risk jurors saying they want to drop out, because that would create some problems. I don't even know how that would work. If you had to substitute a juror between guilt and penalty, I think that you'd have to start over again if you actually wanted to pursue that. So usually the judges are kind of always concerned with losing a juror. And at that crucial point, I imagine the judge would say, we're starting this thing either this afternoon or tomorrow. Get yourselves prepared. But great question. The answer is there's no rules on a lot of this stuff. It's up to the judge. If the judge wants to give a continuance, the judge can. But we'll never know if that would have happened in this case, because this is never going to trial. But great question, JD. All right. Let's keep it moving here.
Hi, Josh. This is Deb from Rochester, Minnesota. I'm calling about a case that just doesn't seem like it's been getting the attention that it deserves. It's a Mayo Clinic doctor, Connor Bowman, and he was charged with premeditation murder of his wife, Betty Bowman, where she died of poisoning. And it just seems like it hasn't really gone anywhere. This happened in August of 2023. I'm just wondering if you could give any details on what's happening with this case. Again, Deb from Rochester, Minnesota. Thank you.
Deb, thank you so much. Let's put Rochester on the map there. I don't know if that's zoom out for a second. Where's that? What is the big metropolis above that? Where am I? I'm trying to orient myself. Oh, I can't see. God, my eyes are bad. Anyhow, there we go. Okay, I get it. I know where you're at now, Deb. Deb asks about the Connor Bowman case, who he is standing trial for the murder of his wife, Betty Jo Bowman. There he is. This did happen out of Minnesota, and this was out of August. What a lovely picture of her. So sad, these cases. This is out of August of 2023, and he is accused of using gout medicine. And that was a big part of how they were able to link this to him, is who has access to gout medicine. We're not talking any kind of over-the-counter stuff that you could get your hands on. It makes me think there was a recent case here in California where the defendant had used nicotine in liquid form to kill someone, to inject it into someone. Really bizarre use. But that is at least something that people without a medical license have access to. Gout medicine is something that you're going to have to be a doctor or have gout to have access to it. Of course, there's all the hallmark signs of this. They were having marriage problems. He was having financial problems. He's a selfish, horrible human being who can't figure out any other way to solve those problems but to kill his beautiful wife here. And what happened recently is the police had seized 14 electronic devices. And recently, the prosecution suffered a huge setback because the judge tossed, I believe, 13 of the 14 warrants. And what this came down to was an issue of what we call particularity when it come to these electronic devices. I'm going to read you a quote from the judge and then explain to you what's going on here. This is Judge Kathy Wallace, said that the prosecution, or rather the law enforcement, failed to meet the particularity requirement, which prevents law enforcement from having unbridled discretion in determining what items should be searched or seized, and from engaging in general searches and exploratory rummaging. I like that term, exploratory rummaging. Here's what's going on. Until about 10, 15 years ago, it used to be that police could arrest someone, take their phone off of them, conduct a search warrant on their home, seize all their electronic devices, and just pour through everything. I remember when I was still in the prosecutor's office, I had a case involving a shooting that took place at a barbecue. One guy shot another guy. They seized that defendant's cell phone and just tossed it, handed over to me. This is how I'm going to date myself, but handed over to me a stack of like 40 CDs that was this person's entire cell phone. No question about whether or not we had access to that. The Supreme Court came out with a decision where they said, listen, cell phones are not like wallets. This isn't like seizing a wallet from someone's person when you arrest them, rummaging through the wallet, finding a identification, finding, a receipt for gout medication, whatever. Your cell phones, electronic devices, have so much information on them. It's got your calendar. It's got your geolocation. It's got your financial documents. It's got photographs. It's got text messages. It's got emails. It goes on and on and on and on and on. We cannot just let law enforcement basically have unfettered access to this person's entire life just because that person had a cell phone on them or just because they have electronic devices in their home. So there's essentially two requirements now. One is, and the judge doesn't even talk about that here, but one, you have to show a nexus between the phone and the crime. So in this case, it would be, what about poisoning someone with gout medication makes you believe that a phone would be involved or an electronic device would be involved? Now, usually you can explain that by saying, well, they're going to be searching for this medication. They're going to perhaps be text messaging people getting access to that information. We want that stuff. Fine. But first you must say, what is the connection here? In other words, you might have a stronger argument for a person who's selling drugs as to why you might need to look at their phone than you will for a person who got in a bar fight. What does a bar fight that leads to somebody's death have to do with what's on that person's cell phone, right? And then the other part of this is that you have to be particular about it. You have to say, I want text messages concerning gout medication from the period of January to March of 2023. That's the part that I'm concerned with. If the warrant lacks those two requirements, then according to many new laws and to the Supreme Court decision, it should be tossed. And the judge did the right thing here. The judge is a very strong, smart judge and did the right thing, because tossing 13 of the 14 warrants is going to be bad for the prosecution. Now, can the prosecution do something about it? Yeah, they can write better warrants and they'll likely be able to get access to the same stuff. But where they have further problems is that many of these warrant piggyback on each other. They get a warrant for a phone, they find out information on the phone, then they get a warrant based upon that information for another electronic device. And now you're seeing where the concept of the fruit of the poisonous tree comes up. So this could absolutely cripple their entire case if they're not concerned with it. I have experience with this. As a defense attorney, I have used this argument many times to great success, because police are stuck in their old ways and oftentimes lazy. And they write these warrants and they go, this guy committed the crime of, I don't know, I'm making something up, murder. I want access to his phone for all time, for all photos, text messages, emails, financial documents, and everything else that I might think to be interesting, because I think that there might be interesting information on there. That is such a lazy warrant. And I'm going to get that tossed by a good judge. Had they just been better about writing the warrant, they probably get all the information they want. So this isn't about sneaky defense attorneys being sleazy and finding loopholes. This is about making law enforcement do their job. So I applaud both the defense here for making the good arguments. I applaud the judge for making a difficult decision. But end of the day, do the job right and you're not going to have these problems. And I think they will be able to go back and get new warrants and clear this whole up, because the person who shouldn't suffer is Betty Jo Bowman. This gentleman should be held accountable for the horrible thing that he did. But great question, Deb from Rochester. I appreciate you asking. I feel like I missed some other comments in here. Okay. Arizona gal, thank you so much. My cousin and her kid survived a serious crash Friday. Oh, I'm so sorry to hear that. Gratefully, they're okay. I'm glad to hear that. She's logged in watching now from her house. Love her so much and love your channel. Well, hello to Arizona gal's cousin. I hope you're doing better. And I'm glad to hear that you're okay. And I hope that you get well soon. K9 Catherine says magnifying glass for Josh. Thank you so much for that. And Redondo Beach says never use biometrics as a password to get into your phone. That's an interesting point too. Here's I think what Redondo Beach is getting at, just as a total aside here. If you have your fingerprint as how you access your phone, which was kind of the previous generations of phones, or you have your face to unlock your phone, the police can use that. They could just put the phone up to your face and unlock your phone. They can put your thumb on the phone and get you to unlock it. They can get warrants for that if they need to. What they can't do is make you tell them what your password is. So if you have your phone set to only unlock with an entered password, they cannot force you to give over that information, because that is considered a statement against your self-interest, and that implicates the Fifth Amendment. But your face and your thumb are not statements, and therefore the Fifth Amendment doesn't apply. So thank you for reminding us of all of that, Redondo. If you guys are up to monkey business, then I suggest that you set it to just be a password and not your face. I have mine set to my face because I'm up to nothing but chasing around kids and wiping butts. All right, let's keep it going here. That was Deb. All right, here we go.
Happy Sunday Funday, Joshua, Tiffany, Kaylin, mods, crew, guests, everyone. It's Alicia K. Mayo from Humboldt, Tennessee, home of the annual Strawberry Festival and Alicia's Home Cooking, and that's about it. But Joshua, a few weeks ago on I believe it was a Members Only Live, you showed a home surveillance video regarding a case of a man you defended, and you made the comment that the camera quality wasn't that great because the lens appeared to be dirty. My question, and it may be odd and silly, but do you have any tips and tricks on surveillance camera maintenance? Obviously, the lens needs to be cleaned periodically, but how often, with what kind of product, and any other hints and tricks? Thanks. Y'all have a great Sunday fun day. Bye.
Alicia K. Mayo, always great to hear from you from Humboldt, Tennessee. Let's put Humboldt back on the map there. Alicia K. Mayo asked a question about, I had referenced a case that I'm working on as a defense attorney, a client of mine, where there was a surveillance footage. It was a big piece of evidence, and that it was very blurry, and that there might have been some stuff on the camera lens. And she, Alicia K, is asking, what other than cleaning my lens, what are other tips about surveillance cameras? I'll tell you, I've got some great tips. First of all, turn it on. We went out to the neighborhood where my client lived, and there were surveillance cameras on nearly every single home there. It was so funny. That neighborhood, very few people had lighting out in front of their homes, which was surprising to me. but almost every single home had some sort of surveillance camera, whether it was a Ring camera or like an older type surveillance camera or whatever it was. Nearly every home. We went around and spoke to as many neighbors as we could. And I would say 9 out of 10 of them, the cameras didn't work or they weren't turned on. Or they were turned on, but they didn't record footage. They wouldn't keep the footage. They were just kind of a live stream of what was going on, and it wouldn't store it anywhere. That blew my mind. Yeah, if you want to get the use out of your camera, make sure it's turned on, make sure it's still running, and make sure that it's saving the footage. And by the way, make sure it's saving the footage for a considerable period of time. I'm talking 30, 60, 90 days, because you would be surprised how often law enforcement doesn't get around to collecting something until much later. And if that footage has been overwritten, which is a very common problem, if many times, liquor store robberies, police aren't able to put it all together until later. And by the time they go back and try to get that footage, it's gone. 15 days later, it's an overwrite, or 30 days later, it's an overwrite. So great question, Alicia K. Mayo from Humboldt, Tennessee. Make sure it's turned on, make sure it's cleaned up, and make sure it's storing the footage. And by the way, one last footnote on that case I did mention, I got my client a very good result. He is home with his wife and beautiful children to this day, and we are very, very happy about how that all worked out. So thank you for bringing that up. All right, let's keep it rolling.
Hello, Courtroom Confidential. I'm not sure what happened last week. I had technical difficulties. Hopefully, this is working this week. I am calling regarding Christina Formella. And anybody who's her, if you know, you know. But she has just now gained, I believe, an extra 59 charges. What is going on here? I think this might be a phone a friend. It actually could be G, because I think she is definitely doing this case in detail. What a case. Oh my gosh. It's Illinois. And actually somebody I work with, her sister knows this woman and I guess is trying to be her friend, but gosh, I don't know why 59 more charges. Okay. Thank you. Have a good time. Have a good day. Bye all.
Thank you so much, Sonia. Good to hear from you from Chicago, Illinois. And I think Gisela did comment on this. Did I just miss that? Oh, yeah. Yeah, Gisela brings this up. She recently requested. So I'm going to get into the story of this woman. First of all, there's Chicago on the map. Christina Formella. She is an Illinois special education teacher, and it has been discovered that she was having, there she is, she was having a relationship with a teenage student of hers who was actually, I think it was a soccer, she coached the soccer team, he was on the soccer team since the age of 14. They believe that this all began. And she recently asked to have the stay away order restriction, as Gisela points out, reduced, which is not a good look. Okay. I don't know what the reasons behind it are exactly, but if you were my client, I'd be like, okay, let's just sit tight about trying to get closer to the victim who you sexually assaulted for multiple times since the time they were the age of 14. Let's kind of put the brakes on that one, put a pin in that one for right now. But Sonia's question is, where are all these charges coming from? Well, the charges are coming from how many times they believe she had sexual intercourse with this young person. They believe it was in excess of 50 times. There she is there with her husband, by the way, supporting her. I am not trying to throw shade about people's relationships and what they are going through, but I am really shocked that he is continuing to support her through this whole thing. So we're talking 50 times that they believe, this R word took place of this young man. So they've added 52 additional charges, Sonia, making the total of 55. And that's exactly how these cases usually work out. This is not, each one of these instances is considered a crime, and they will be charged that way. And she is looking at decades upon decades in prison because of that, because many times with these SA type cases, they will stack the charges, meaning that they will be run consecutively rather than concurrently. And she could be looking at a tremendous amount of time. And the reason this all was exposed is the victim's mother saw some text messages which were incredibly explicit. I mean, things to the point of, I think she texted him, "I really enjoy having sex with you." I mean, it was just red-handed type of stuff, admissions. And then they were able to seize her phone. Going back to our earlier question, they obviously have probable cause to get to her phone, to get the other sides of these text messages. And she apparently had kept some sort of memoir on her phone memorializing all of these instances. So really sick, horrible stuff. It's again one of those kind of gender roles being switched types of situations where, you can imagine, as sick as Esme Grief is about this now, you can imagine how we would all be feeling about it if we're a male 28-year-old and a female 14-year-old. We'd be talking about putting this person under the prison, but it's just as disturbing and awful with the roles being switched. Yeah, what a horrific case. If you do yourselves a favor too and try to find the arrest footage of her, and you can literally see this person's mind collapsing behind her eyes when she realizes it's all over. Thank you so much, Sonia, for reminding us of that case, and a case apparently that Gisela has been following closely. So make sure you'll check it out on her channel. Trina says, Trina, thank you so much for gifting the memberships. Oh, Redondo says, are you suggesting I'm up to monkey business? Absolutely not, Redondo, but switch it over to your passcode. And Jeanette, hello, my friend. Thank you so much for the super sticker. We ran into each other in Boise, Idaho. Boise was a happening place this last week. We were all of the cool kids were up in Boise, and so I got to hang out and grab a quick coffee with Anjanette in the beautiful lounge of the Boise airport. So it was so good to run into you, and thank you for saying hi this morning. All right, let's keep it going.
Hey, Josh, and all Courtroom Confidential people. I'm not really sure what to call you, but this is Wendy from Nicholasville, Kentucky again. If you recall, I last asked you on Sunday Fun Day if Bryan Kohberger would take a plea deal. And now I'm watching you on the Grizzly channel, and he took a plea deal. I mean, did I speak this into existence? Am I psychic? Oh my gosh, maybe I need to play the lottery. But anyways, what do you think about this? Because I'm freaking mind blown. I mean, like, what the hell? Anyways, can you tell me what you think about this? Have a great day. Bye.
Wendy, Nicholasville, Kentucky. Let's put you on the map. I do remember this question, Wendy. I remember being asked, do I think a plea deal is in the works? Is it happening? And my thought was absolutely not. I am shocked. I was out there saying, no way. This is a death penalty type of case. If you're going to have the death penalty, they're going to pursue it in this case. They changed the laws in Idaho to make sure that they would have a suitable forum to actually execute him with the firing squad. They had fought tooth and nail for months about whether or not the death penalty would be on the table. The defense had fought tooth and I mean, everything about this. The judge had even asked them prior, have you considered all possible disposition efforts? Everything about this pointed towards this thing going to trial. And it was just whip your head around shocking that it ended the way it is. So if you want to know my reaction, Wendy, my reaction was absolute shock. I'll tell you exactly how my reaction went down. It was on Monday, and I think I was getting ready for our Monday live that evening, and I hear Tiffany from the other room go, gasp. And I go, what's up? And she goes, Bryan Kohberger is accepting a plea deal. And I said, that's not true. And she said, it's on Twitter. And I go, well, Twitter's garbage. And I said, who's saying it? And she said, Brian Enton. And I went, oh my, it's true. Because Brian is a fabulous reporter over at News Nation who's been following this case since the beginning very closely, doing some really good work on it. And I immediately texted Kevin Fixler and said, is this true? And he said, I'm working on it. It looks like it might be true if Brian's the one saying it. And I just am going to give you guys a little tease. You may be hearing from Brian on this channel coming up soon. But that was my reaction, Wendy. I was completely shocked. And I will be honest, a little frustrated, a little bothered, a feeling like this isn't the right thing to do. But the more I thought about it, I think the way to best think about it is this. And I'll be quick about this because I've talked about it quite a bit. Trials are never guaranteed. You put your chances into the hands of 12 strangers who don't know each other, you'd be surprised at the results you get sometimes. We've all seen verdicts that are mind-blowing to us. That there is a chance out there. Maybe a small chance, but still a chance. 2, had he even been convicted, there's no guarantee he would have received the death penalty. That same jury, as we pointed out, could convict him and then decide not to give him the death penalty. They have to agree on that unanimously as well. And they could have just decided not to. And then we would have ended up exactly where we are today, but actually worse off. And here's why. Had he been convicted after a jury and either given the death penalty or not, what would have followed would have been decades of appeals. And they would have questioned every decision the judges made. Every single thing that Ann Taylor fought for and got denied would have become a point on appeal. And he may have won one of those down the road. And it may have overturned his death penalty conviction. Or it may have, worse yet, overturned his conviction and gave him the opportunity at a retrial. That's the real tragedy that could have occurred, is something like that happening years and years down the road. So as much as I am frustrated and I appreciate what the victims' families are going through, and my heart goes out to them, and I give them the space to grieve however they want. End of the day, this is the most rock solid result that could have come out of this. That man has admitted what he's done. We heard that out of his own mouth. He is now convicted and forever will be convicted. And there's no chance of us ever hearing about him again. Think of the Menendez brothers, 30-something years later, and they've got a chance of getting out. That's because they have the opportunity to appeal. Bryan Kohberger will not have that same opportunity. So as it's all kind of still setting in, I was even saying to Tiffany this morning, I can't believe that case is that he took a plea. I mean, it was just so many plans and things just kind of went out the window after that. But thank you so much, Wendy. Appreciate you. Thank you, Laura Waldy, for the gift of membership. Appreciate that. Thank you, Marie Jubenville. Says, I wish Kohberger would have explained what he did like BTK. Yeah, that is another thing that frustrates me. I wish we would have had more of an opportunity to hear some insights as to what took place and the why. Why? Explain yourself why you did this, why you robbed from 4 families something that they will never heal from completely. Explain that, and we'll never have that. Brooklyn Janet says, Josh, will you be at CrimeCon this September in Denver? I will. True crime is my new hobby. So fascinating. Brooklyn, yes, we will. We will be at CrimeCon. We're setting up a booth and everything. We're planning on doing a whole big, I don't know, what do we call it? We're bringing the circus. We're bringing the Courtroom Confidential circus to Denver. We will be there. stay to the end. We actually have some announcements about that for you all. But yes, we look forward to meeting you, Brooklyn. Redondo says, Bill T is a coward. Email to the family speaking about intent in court. I get it, but handled poorly. I think I would agree with all of that too. The one thing I don't know is I know they sent an email saying this is what's happening, but I don't know if that means that they weren't discussing all of this with the families ahead of time. It might have been where they had these discussions, told them they were going to do this, and then the email was actually informing them of it. But it did seem like a very cold and callous way to go about doing it. So yeah, a lot of people are upset, and for very good reasons. But end of the day, I think it's a as far as results wise, a good result. All right. Shall we keep it moving here? Everybody says yes all at once.
Hi, Josh. This is Stefana Eastup up in Coeur d'Alene, Idaho. I'm just calling to let you know you can disregard my question that was previous regarding Bryan Kohberger's case because it's probably a moot point at this point. But I do have questions regarding Kouri Richins, and that has to do with her financial crimes. There's new ones brought in, but from what I understand now that they're being tried separately, or the judge allowed them to separate them from the murder trial. And I was wondering why he would do this. And will they be allowed to be brought in, or even should they be allowed to be brought into the murder trial? And if not, why? She hasn't been convicted of them yet. It seems to be the primary motive for the murder of her husband. So I'm just wondering how this all works, and if you could explain why they would separate these charges and how they could bring them in still to show their case. I'd really appreciate it. And thank you for all you do. And we're all safe here now again in Coeur d'Alene. So just thanking everybody for their support for our little community. Thanks. Bye.
Thank you so much, Fauna from Coeur d'Alene, Idaho. Yeah, the northern half of Idaho has seen its more than its fair share of tragedy. Coeur d'Alene, my understanding, is not all that far from Moscow, and in fact, I think one of the girls was actually from there. You guys probably know. I think it was Xana was actually from Coeur d'Alene, and then recently this horrible shooting involving someone who had set a trap, lighting a fire, and two responding firefighters lost their lives. Frank Harwood there on the left and John Morrison on the right. What an absolute tragedy. Just firefighters, out there just being heroes, saving lives, putting their lives on the line, and for this kind of a thing to take place. So thank you, Fauna, for telling us all how the community is recovering up there. But you ask a excellent question about the Kouri Richins case. She recently, the big news in that case is that she had 26 new charges leveled against her, and they're all financial charges. So we've got mortgage fraud, money laundering, forgery, bad checks, several counts of each of those. And Fauna's question is, why isn't this part of the murder case? Can it be part of the murder case? What is going on with that? The answer to that is it's just too late, I think, more than anything. If they were to add this to the murder case, then the judge would have to continue this thing out for another 6 months, I think. So the prosecution, I don't know why they waited so long to do this, but has decided to only bring these charges now. Could they have been part of the case? I think so. Had they been originally charged along with the murder, I do see a connection between them. It is, as you point out, Fauna, the motive for the murder was likely financial. So let's get into it and go ahead and present that. It could also be, though, that they don't want to unduly influence the jury. I don't think that would be a problem here. It's not like you're going to believe somebody committed murder because they've also committed financial crimes. Here's the point I'm trying to make. A person who commits financial crimes, you're not going to mistakenly say that's the same character of person who's going to commit murder. What they want to use it, though, is as motive, which is a different question. Is the person who committed financial crimes because they're in dire straits financially going to be motivated to commit something like murder for life insurance or whatever other gain? Yes. So to answer your question, I think they will still be able to get into much of this during the trial as it relates to motive. But the fact that she's been charged with these things, or all of the down and dirty circumstances and details of it, probably not so much. It reminds me of the Alec Murdaugh case from, how long ago was that now? Are we talking 2 years, a year ago, maybe longer? Yeah, Lola's mom brings that up too. Same thing. Financial motivation all over the place, but the murder trial was handled separately from that. But the financial crimes and issues became a part of the murder case because you can't explain why this person did this without explaining the financial pressures that they were under. IGG Rock says Kouri Richins is scrappy but not smart. Yeah, I would probably agree with that assessment. So yeah, I think the Murdaugh case is instructive of that, to understanding how it probably will go down in the Kouri Richins case. But that case, when is that set to go to trial? I think it's not until the beginning of next year, which is unfortunate because that was one that we were following closely and was hoping to come up sooner than that. But she will be in court soon enough. February of 2026, says T. Suze, and T. Suze knows her stuff. So that's another case that we're going to be following very closely. We're trying to pick, by the way, the next new case that we're going to follow on our sister channel, CC Live Trials. So if you guys have ideas of something that's coming up soon, I think James Craig is top of our list, but that's just going to be opening and closing statements. They're not going to actually stream the entire trial, but we'll have what parts we can on CC Live Trials. But thank you, Fauna. Appreciate you. Let's keep it rolling here.
Hey, Josh and Derek here in Santa Barbara, loving your show. Just a comment about the Brooks Houck trial that's taking place in Kentucky. And it's not being broadcast or streamed. And only a few YouTube podcaster type people like Lawyer Lee are covering it. And she's doing a good job, and she's very detail oriented. Maybe you and she will get together sometime. And I know that Gisela is covering it too. And I know you've worked with her. But I also wanted to give a shout out to the best coverage, which is from the local Louisville TV station, WHAS 11. They're doing a phenomenal job. Great reporters who really know the case, especially this one reporter who's just really good. The host is really sharp and knowledgeable, and the legal consultant, who's a defense attorney, former prosecutor, is also giving a lot of insight. So they're doing a great job. And I contrast that with the horrible coverage that was done by the mass media, the TV stations on the Karen Reed trial, particularly Canton Confidential, NBC 10 in Boston, which did a horrible job. So just wanted to mention that. Perhaps you'll cover that case in the future. Thanks, Josh. Doing a great job. Take care.
Thank you, my friend Derek from Santa Barbara. Appreciate, always nice to hear from you. Yeah, let's put Santa Barbara on the map. Home of Brophies. So this is a case that I know a lot of you guys have been following closely. We are going to follow it more closely. We've been a little distracted with Bryan Kohberger and Sean Combs and a bunch of other stuff, but a really awful case. Brooks Houck, along with Joseph Lawson, are on trial for the murder of Crystal Rogers, whose body has still never been recovered. And it's a really one of those awful cases. One of these cases where you just say to yourself, why in the world? Why does it have to end up with murder? Why does it have to end up with tragedy and ruining people's lives? But this is out of Kentucky. It's actually just saw the 10-year mark from when she went missing. She went missing on July 3rd of 2015. Gisela, who's been following it more closely than we have, says it's very circumstantial and sounding a bit shaky. That's not good to hear. It's a no-body case. Her body has never been discovered. Houck was her ex-boyfriend. He's charged with murder. Lawson is charged with conspiracy. Lawson's father, Steve Lawson, was actually already convicted in May of conspiracy. And the case relies heavily on motive, circumstantial evidence, as Gisela points out. And they believe that this family was somehow involved. His brother, Nick Houck, who was formerly a police officer, and her grandmother, apparently there's conversations that took place. They believe that they just wanted to get rid of her. He made a comment to someone saying something like, yeah, I'm getting rid of her. And there was a lot of kind of subterfuge about the vehicle that this murder may have taken place in being sold. And we're talking about a case that's 10 years old, so it's a cold case, a no-body case, a case with no physical evidence, very little physical evidence. There's some like dog, canine evidence, whether or not the cadaver dogs found anything. It's a difficult case to begin with, and it sounds like it might be having some trouble. So that would be really sad if it didn't bring justice to her family. Because let's say you keep so many case facts with so many cases. Yeah, what I do is I forget the most basic things, like how to tie my shoes and drive a car correctly, so I have space for all of these true crime facts. But thank you, Derek, so much for asking the question. A case that we will try to put some more coverage into. It was on our weekly roundup, by the way. So if you missed it yesterday, we talked about it. Closing arguments Monday, deliberations Tuesday. So it's coming to a conclusion quickly here. We talked about it yesterday. We did our kind of abbreviated weekly roundup because of the holiday. So it was just kind of a more casual weekly roundup, but we did give you some updates on that case. If you guys want to check it out, it's up on our channel now. Thank you, my friend. Derek, Santa Barbara. Have a drink at Brophy's for me. All right.
Hey, Josh and crew, thank you for the opportunity to be heard. This is Janet Moorcraft from Boca Raton, Florida. I was watching the Kohberger trial where he admits to doing that horrendous killings of those 4 beautiful young students. But I was also watching Bryan Kohberger's parents, and I kept noticing his father lowering his head as his son admitted to committing the crimes. What do you think it was like for his parents? I don't know if his sisters were there. Could you tell us what you observed when you were in the courtroom? And in your past cases, what is it like for the family members of someone who commits such a heinous crime? They are also victims. Your thoughts. Thank you all. Have a beautiful day.
Thank you, Janet, from Boca Raton, Florida. Let's put you back up on the map there. And then while we're doing that, I'm going to do this wrong. Monbet for saying, please cover the Massachusetts versus Brian Walsh case. I'm all over that case. We've been following that case since early on. We actually did a case notes episode, if you want to check it out, on the Brian Walsh case. Maybe I'll get Tiffany or Kaylin to quickly throw up a link to that. Now I can see panic mode setting in with everybody. But it is a very, very, it's another no-body case, a case that we will be following closely. I'm not sure if it's going to be televised, but if it is, we will be putting that up. But thank you for reminding us of that. Janet, back to your question about Bryan Kohberger and his parents and how they are also victims. I'm glad that you brought this up. This is sometimes difficult to talk about. True crime in this world that we're all a part of, it is not always black and white. It is not always bad guys and good guys clearly distinct from each other. And I think it's unfair to villainize the defendant's family as if they're responsible or somehow they did something. Bryan Kohberger is a real anomaly. I did a lot of research. I've read all the books that everybody's come out with, watched every documentary. We were following this case very closely. There is nothing that I heard in his background about his parents, about his family, or about the way that he grew up that made me go, I get it. I get what created this monster. His family was very poor, but his father sounds like he was very hardworking. Sounds like he had a lot of love and support in his house. He went through a period of time where he had a heroin addiction, and his father helped him through that. It wasn't like he had a heroin addiction because of his family. Kathy Davis says, Anjanette Levy has a live stream. Oh, I missed it. So Tiffany, can you go back to that one comment? There we go. Live has a stream on what she observed in court. It's horrifying for his parents. Yes. It is, I mean, think about this. His father flew from Pennsylvania out to Pullman to just drive with his son back to Washington, to Pennsylvania, just to take a drive with his son, to spend time with him, help him get his car back home. We're not hearing about years of abuse, psychological, emotional, physical abuse. We're not hearing about foster care and all of this kind of stuff that you might, violence in the home that you might say, I get it. He's an anomaly. He's a broken person that became evil and twisted and demented and did a horrible, horrible thing. And because of that, I do think that in fairness and realizing it's not all about black and white and good and bad, there is gray area. His family are victims in all of this too. And I've seen that many times as a prosecutor, that the defendant is ruining the lives of his family as well. When you're prosecuting someone for doing something horrible and you know that you're sending that person off to prison for the rest of their life, and that person is a daddy to the little girl who's in court watching this whole thing at the age of 5 or 6, that's horrible stuff. That's horrible stuff to know that she is now saying goodbye to her father. And the next time she'll ever see him, if she ever sees him again, will be through prison bars, is horrible stuff. He's ruined her little life and she didn't deserve that. Same thing with his family member. I can't imagine what it is like to carry the name Kohberger in Pennsylvania at this point moving forward. So yes, Janet, I appreciate you bringing that up. He's ruined the lives and irreparably harmed the lives of Ethan, Xana, Kaylee, and Madison's families. And this is not to make comparisons or try to draw comparisons, but he has also ruined the life of his own family and they will forever be touched by this. So that's my little soapbox. Thank you, Janet. I appreciate you bringing that up. Let's keep it moving here.
Hello, Courtroom Confidential friends, and shout out to the Grizzlies out there. This is Kimmy Cloverberry from Turner, Maine. I do believe you have me on the map. I wanted to first acknowledge and thank you for the collaboration that you've done with Gisela K and with the Sarge. I think, that's how you guys can expand your reach, and also for somebody like me, the viewer or listener in some cases, can really get a lot of information. And the three of you, so Gisela, Joshua, and the Sarge, I think you guys would have such an awesome show together if you ever wanted to do a collaboration, a little spin-off. Anyway, to my question, it's about Bryan Kohberger and the whole plea agreement thing. I'm questioning, is the death penalty off the table? Because the judge did ask him recently, has anybody offered you anything in exchange for your plea agreement, which he says no. So then didn't they take the death penalty off? the agenda? And isn't that, them offering him something in exchange for something? If you could explain, I'd really appreciate it. Thank you so much. Talk to you guys later. Bye.
Thank you so much, Kimmy from Turner, Maine. Good to hear from you. Yes, big shout out to Gisela and Grizzly True Crime. I love to see when my chat lights up with the bear faces. Gisela says, Josh and the Sarge are my favorites. Well, you're my favorite. And the Sarge, too. Joe Giacalone from True Crime with the Sarge, also a big fan of his. And I've been on his show. He's been on mine. So thank you so much for sending the love, Kimmy. And next time you're on Gisela's channel or you're on Joe the Sarge's channel, please send him some love from us. Tell him, say hi from Courtroom Confidential. They're both big supporters and inspirations to me. So to your question, yes, the death penalty is off the table. And yes, I understand your confusion when the judge asks that kind of a question. Did anyone offer you anything in exchange for your plea today? That is a really funny question because obviously you've been offered something. That's why you're taking a plea today. What this question is concerned with, though, is did somebody offer you something not as a part of this plea arrangement? In other words, have you been bribed? Have you been threatened? Have you been told that your family will be taken care of? All of these types of things is what the court is concerned with. Is there something outside of what's being discussed here in court, the plea bargain and the benefits of that might be benefiting you? So yes, what he is gaining, what he has been offered in exchange for his plea, is that they will not pursue the death penalty. So that has been offered to him. But aside from that, nothing has been offered to him. And in fact, what has been required of him is to waive his right to appeal, which, as I've discussed earlier, is hugely impactful in all of this. And he pled guilty and he admitted killing those beautiful girls and boy. Yeah, the more and more you think about it, just a horrific, horrific case that did not end the way that all of us would have expected. So many times during the plea, you'll hear the judge. One of the things that always I get questions from people about too is when the judge says, "Are you pleading here today because you feel that it's in your best interest to do so?" How is it in my best interest to go to prison? Well, it's in your best interest because you're avoiding the death penalty. So anyhow, thank you, Kimmy from Maine. Appreciate you asking the questions that maybe a lot of people have been wondering about too.
Hi, Josh. Kimberly Rutherford, Wildorado, Texas. Listen, I'm just calling because of the whole Bryan Kohberger situation. I am pleased for the families who had no desire to hear the dirty details about their dear loved ones' murders. I, however, totally understand the other families' feeling of betrayal, that they were not represented in the way they desired. And while I struggle with the death penalty, I recognize that if we are going to have it, in what other situation would we ever need it other than a savage who brutally slaughtered 4 young, beautiful people? If it's not used now, when would it ever be appropriate? If we're not going to use it, why have it? Thanks. Appreciate it. Can't wait for Sunday Fun Day. Bye.
Kimberly, you are preaching to the converted. I completely agree with you. Let's first of all put Wildorado, Texas on the map. I appreciate you saying Wildorado too, because I would have pronounced it Wildorado and been mocked by everybody in Texas. So thank you for saving me from that embarrassment. Great to hear from you. Great comments. I agree with you. And this was the part that initially bothered me the most is, what is the point of having the death penalty if it's not for this situation? Putting aside whatever ethical, moral, religious, political views you have on the death penalty, if it's on the books, it should be reserved for a case like this. Multiple murder, nearly motiveless murder, loss of life, just horrific. Everything about it, everything that you just put so eloquently, Kimberly, is the reason why the death penalty, if it exists, should be applied. I'll do you one better. There's no death penalty in Washington. He went from Washington to Idaho, where there is a death penalty, to kill 4 people. Shouldn't Idaho say, not in our state? I mean, that's the whole point, is if this is even about discouraging people, which I don't think is the point of it, but even if it is about that, then handle your business, Idaho. Again, that all being said, our frustrations all being voiced, I get it. I understand why the prosecution did what they did. I think there is a tremendous benefit in having done what they did. But to your question, Kimberly, this is not uncommon. The death penalty, when people talk to me about, why do we even have it? We never use it. It's never applied. People just sit in prison for decades anyways. There's no deterrent element to it. I'll tell you why. The biggest benefit to it is situations like this. This is not uncommon, to have a person looking at the death penalty and willing to plead to avoid the death penalty. Happens all the time. Most cases, well, maybe not most. I'd have to look at the statistics, but I experienced it many times as a prosecutor, that we would offer, they would say, what do we do? How can we get out of this? My client doesn't want to sit on death row. Great. Plead. We'll take death penalty off the table. They're going to life without parole. They have to admit to everything, tell us where their bodies are, whatever else. It happens quite often because it's not as much of a deterrent as it is a real motivator for someone to admit to something. Think about it here. If it wasn't on the table, why would he plead? At that point, he might as well take his chances, but he pled to avoid sitting on death row. So thank you, Kimberly. Excellent question. And thank you for voicing what a lot of us have been thinking and feeling. How are we doing? Are you guys enjoying this? We got a bunch of people in the chat. We got a great group today. We're talking about a lot of different subjects. We got mainly Bryan Kohberger, but we've been all over the world with questions, and all over talking about the Brooks Houck case and the Christina Formella case, Connor Bowman, a lot of stuff. So I hope you guys are enjoying. I'm thoroughly enjoying. I'm juiced. Is everybody juiced? Let's see those juice boxes if you agree. But thank you again for Kimberly from Wildorado, Texas. Appreciate the call. Appreciate the comments. Appreciate you sharing your thoughts with us. Kaylin's juiced. Look at her. Kaylin's always juiced. She's always in a great mood. I can never find Kaylin in a bad mood. I like that. All right, let's keep it going here.
Hey community, this is CJ in LA from Los Angeles. I hope you're all doing well and enjoying your Sunday. What a week it's been in true crime. I don't have a question, but more of a rumination, if you will. I've been deeply agonized thinking about the plea deal in Idaho. I intentionally don't say his name. In fact, he's lost and forfeited that right to an identity other than murderer at this point. I've heard the pundits say that the DA represents the community at large and not necessarily the individual victims per se. And yet, how can you see Steve Gonsalves outside of the courtroom, anguished and outraged, and not say that the plea deal was just an awful bust? I get it. I'm a parent, and I can't fathom the horror that the families live with each day. but perhaps the upheaval of a trial would have been worse. I don't know. This case absolutely gutted me, and I guess I'll just end this by saying the names of the lives that did matter: Ethan, Xana, Kaylee, and Madison. Thanks so much, all.
Really well put, CJ. Thank you so much for that. Thank you. I again, I don't disagree with you. Thank you. This is CJ calling from Los Angeles. Always appreciate your calls. Always so well said and well put. I don't know. What do you say? I mean, listen, Steve Gonzalez and every one of these families can grieve and feel every way they want to feel about this. I cannot imagine the nightmare that they live with every single day. I cannot fathom what it would be like to experience this. And I completely empathize with and understand wanting vengeance. I mean, let's just say it, wanting justice, but more than justice, wanting vengeance, wanting this person off of the face of the earth, wanting to know that you no longer breathe air on the same planet as this monster that took away these beautiful children. Ethan, Xana, Kaylee, and Madison. I understand that. And I'm not going to get into all the reasons why I understand the plea deal. I think CJ raises a good question. Would the trial have made us feel any better? I don't know. Would it have made Steve Gonzalez feel any better? I don't know. I don't know if he would feel anything better than the pain and heartbreaking life he's living right now. Would any of that have been any better 3 to 4 months from now, hearing that the jury says that they've announced the death penalty against that person? I know he feels that way now. I know he says that he wants that, but I don't know if that would actually bring about any more healing. And would it have brought about any more healing to hear that Bryan Kohberger is appealing this 10 years from now? He's appealing that 20 years from now, whatever it is. Far be it from me to cast any kind of judgment on what these people are experiencing and each of these families and how they're handling it. I know some families were in support of it and wanted it to be done this way, wanted to put it behind them and try to move on with the healing process. And so I feel as much for them as I do for the Gonzalez family, what they're going through. Just, that's this case we knew was always going to be ground shifting from the second that we heard about these murders taking place. I will never forget hearing about these murders and seeing those images with the blood dripping down the wall from the outside is something I still cannot wrap my head around how horrific the inside of that home must have been like. Thank you, CJ. Always great to hear from you. All right. Let's keep it going here.
Hi, Josh. This is Dakini from Baltimore, Maryland. I love your show. My question is in regards to Kohberger's sentencing. Can the judge set restrictions on media interviews with him? I feel like his motive was surely to become famous and as a killer. And I hate to see him, get that. So thank you. That's it. See you later. Bye.
Thank you so much, Dakini from Baltimore, Maryland. Let's put you on the map. And thank you, Kay Schmidt, for the gift of memberships. I appreciate that. All the support. Everybody's been so kind and generous this morning. Thank you guys so much. I'm so glad you're enjoying it and supporting the channel and helping us to continue to do this every single week. So thank you, Kay Schmidt. Dakini, excellent question. What happens now with Bryan Kohberger? Can the judge restrict his media interviews? The short answer is Judge Stephen Hippler cannot. We're talking about, as horrible as it may sound, Bryan Kohberger is still an American citizen who still has certain rights according to the Constitution. Many of those rights he has forfeited, but some of those rights he maintains. And one of those rights that he maintains is a First Amendment right to speak. And the judge cannot place upon him what is called prior restraint to just prohibit him from speaking altogether. Thank you so much, Anita Gendler, for the super sticker. So appreciate your support. But that being said, there are restrictions on him profiting from that. And there are restrictions that can come from the Department of Corrections as far as access that reporters and media people might have to him, if you can see what I'm saying. The judge can't say, Bryan Kohberger, you're not allowed to speak to the media. But the Department of Corrections in Idaho can say, you know what, Bryan's not available today. And Bryan might not be available for a while because he's in solitary or what have you. But what they can do, and what Idaho has done, Idaho has a law called the Criminal Profiteering Act, and it prohibits, this is very similar to what we have heard of before as the Son of Sam laws. David Berkowitz, the Son of Sam, there were laws put into place to make sure that he couldn't get book deals and whatever other kind of marketing, get paid for interviews or anything else. Now, the way that usually works is it's not that the person can't give the interview and can't have a book deal and can't have, be part of documentaries and sell their rights and everything else. They just can't receive any of the money from that. That all of the proceeds of that they are forfeiting, and all of that will go towards victim compensation. So if Bryan Kohberger does give an interview, if Bryan Kohberger is part of some sort of book down the road, which I wouldn't be surprised if it happens, all of those proceeds will go to the victims' families in this case. So great question, Dakini. No one is able to profit off of their crimes. We won't allow for that, but don't be surprised if this isn't the last time that you heard from him. I have the feeling that this psychopath we're looking at right here, I have the feeling it's not the last time we heard from him. Something about him says to me, he's going to want to be heard, and he's going to want to somehow tell his quote unquote story. So if anybody cares to hear it, just know that he's not going to be profiting off of it. Jody says they don't care about money, they care about fame. That's true. I don't care how many bucks you have to your name. It can only buy you so many, peanut butter sandwiches at the commissary. So who knows if he might want to do it just for the notoriety. But again, there's the court has a concern of balancing securities, prison security against his First Amendment rights, and just completely saying you can't talk is not something a judge can actually order. All right, we're getting down to the final few here. Oh, yeah, I almost skipped somebody. I don't want to do that. All right.
Happy 4th of July, Josh and CC family. This is Sarcasm from Fort Bragg, North Carolina. So the lunacy from the Kohbergers, sometimes they even give me pause. So I spent hours researching the Idaho laws regarding plea deals and the withdrawal of plea deals. And if I read correctly, Bryan can withdraw his guilty plea as long as it's before sentencing. Is that correct? The reason why I ask, I mentioned lunacy. I happened to come across this, and this is what it says. This isn't even close to being over. I feel this is a strategy by Ann Taylor to get the DP off the table. She has fought hard for this. She was just arguing third-party culprit. She said, I believe in his innocence. I feel she needs more time because she doesn't want him off. She wants the corruption exposed. Cy Ray has proof that he wasn't there. Ann Taylor is playing chess. She has a plan. He won't get a fair trial. Movies, books. This is all part of her plan for exoneration. Okay, Somebody shoot me now.
Oh, sarcasm. I feel your sarcasm and I understand your frustration and I feel your pain. First, let's put you on the map. Fort Bragg, North Carolina. Thank you so much. Always great to hear from you. There is a phrase in the criminal justice world of a jailhouse lawyer. Many times, public defenders would complain to me about their client having some harebrained idea or being upset or wanting to file something or do something. And that's because they've been speaking to a jailhouse lawyer, meaning they're speaking to another inmate who's done the smallest amount of research and now decided that they know what's best. And if your lawyer isn't filing XYZ motion, then your lawyer is failing you and you need to fire that guy. I've experienced it myself to a much lesser degree, but people get in there, they get into prison, they talk to other guys, they got nothing to do all day long, but talk about their cases and how they're going to get out and why isn't their lawyer doing this and that. And, oh, your lawyer didn't file a motion to recuse the judge. Well, he needs to file a motion to recuse the judge. Then your client gets all hopped up. And the next time you see him, he says, why haven't you filed a motion to recuse the judge? Jailhouse lawyers. Well, now we have a new phenomenon, sarcasm, which I guess we could call social media lawyers. And you've got a bunch of people out there who've either done zero research or heard it from gossip or just made up some idea in their head. And they know what's going on in this case. Let me just say this. Ann Taylor is a very good and very smart lawyer, but she is not playing 3D chess here. This is not some big, the government fell right into her trap moment and that she's now going to pull a switcheroo and he's going to withdraw his plea and aha, death penalty is no longer on the table. Not how it works. It's called a benefit of the bargain. Okay. They've entered into a contract. That's what it is. The contract is between the government and Bryan Kohberger. After acceptance and consideration. That's what it makes a contract. The offer from the people is you plead guilty and we'll take off the death penalty. He accepted that by pleading guilty. The consideration, meaning the change in hands from both sides, is the prosecution gave up the death penalty and Bryan Kohberger gave up a guilty plea. If that falls apart, then all terms of the contract fall apart, meaning he can go ahead and withdraw his plea. And yes, you're right. Within 30 days, he can withdraw his plea. And we'll get into how he's not just allowed to automatically do that, but how he can withdraw his plea. But if he does withdraw his plea, that withdraws all the terms and death penalty is squarely back on the table. So no, sorry, don't mean to add fuel to the Twitter fights that you're probably already having, but that's not going to happen. He can withdraw his plea before sentencing for what's either called just cause or excusable neglect, meaning he was coerced into it. All those things where the judge says, are you entering this plea willfully, freely, because you feel that it's in your best interest to do so? Has anybody promised you anything? Has anybody threatened you? That's all about coercion. If something comes out that he has been coerced, he's been lied to, he's been threatened, that could be a reason to withdraw his plea. Ineffective assistance of counsel. If somehow Ann Taylor hadn't shared with him some sort of huge piece of exculpatory evidence, he could say, I didn't know about this. That affected my decision-making. I want to change my mind. Or excusable neglect means some sort of misunderstanding. He didn't understand that he was pleading guilty to everything and never having a chance at parole. Something like that. And he would have to explain how that wasn't made abundantly clear to him, both through his attorneys and through the judge in court. I don't think any of that exists here. So he's not going to just be able to walk in and say, I changed my mind. He's going to have to show something. And it's up to the judge's discretion. If he comes in with some BS excuse, I've slept on it now, Your Honor, and I decided I don't want to do this anymore, judge can say, no, sorry. We had a deal. We have a contract. I'm enforcing that contract. And by the way, the result of that is he's just set back to trial. Great. You want to withdraw your plea? You feel like you were not informed correctly of it? I'm going to go ahead and say that's true. You withdraw your plea. We're picking a jury in 2 weeks. And death penalty right back on the table. So, sarcasm, I feel your pain. Try try to ignore the social media lawyers. Lots of folks out there who have microphones and don't know what they're talking about, or just have access to a keyboard and don't know what they're talking about. All right, let's keep it going here before I get myself in trouble. Oops.
This is Afton in Harper, Kansas.
Hold on.
Hi, Josh and crew. This is Afton in Harper, Kansas. I was wondering about plea deals and what happens if evidence comes out later that proves that, say, Bryan Kohberger didn't commit the crime. What level would that evidence have to be to create a change in his situation? Thank you.
What a great bookend to each other. Did you, Afton and Sarcasm, get together and coordinate to ask these questions? Because they both kind of ask the same, different sides of the same question. So Sarcasm's question was, can he withdraw his plea before sentencing? Afton, so good to hear from you. Always great to see you, but it's now great to hear from you. Calling from Harper, Kansas. Let's put you on the map before I forget. Asked, what about after sentencing? Can he withdraw his plea? And what would have to happen for him down the road to say, you did plan it? I knew you guys did. What would happen down the road for him to be able to withdraw his plea after he's been sentenced? So it's a different standard. It's actually a much higher standard. After you've been sentenced, you have to show what the law refers to as some sort of manifest injustice, meaning to allow this plea to remain in place is such a miscarriage of justice that we cannot allow it. So what are we talking about here? We're talking about more than someone else confessing to it, by the way. Other people have tried to withdraw their pleas after saying, hey, this other guy confessed to it. More than just simply exculpatory evidence. We're talking something so convincing that the person who is in prison is not the right person, that it would be a miscarriage of justice to allow them to remain in prison. This is the Innocence Project type of stuff. This is stuff where it's so bad, we have to do something about it. This is where you hear about people being released after 30 years, that somehow them being completely cleared of it. Some sort of ultra convincing DNA evidence. When I say something other than confessing, people confess and then they retract and then they confess and then they retract. That's sometimes not enough. Exculpatory evidence. Oh, we found other DNA in addition to the defendant's DNA. You know, it's the type of stuff that I'm talking like caught on tape type of stuff. The person who confesses knows something so detailed oriented and was in the same location and committed similar crimes and their fingerprint was the partial fingerprint that was found on the, crime scene, whatever it is. We're talking about the type of stuff that you cannot ignore. So we're not just talking about him changing his mind. It's a very different standard. So thank you both, Afton and Sarcasm, for bringing up those topics for us. All right, guys. I hope you're having a good time because we're getting right down to the final 3 at-bats here. Not my fault. Not my fault. Technical difficulties.
Hey, Josh. Johnny Knoxville, a.k.a. Christopher, calling in from Chapel Hill, North Carolina. Happy 4th of July to you, to your family, to everybody else. Just watching Nancy Grace skewer a couple of guests, but my question is this: as I was watching the Diddy coverage, so some of it, not a lot, but I noticed, there's all these courtroom drawings of Diddy. There's no photographs. There's no video. My question is this: it got me thinking. How is it not a violation of the First Amendment to not allow there to be photographs taken in the courtroom or video to be taken in the courtroom for, for news agencies or for the media. I'm not saying like, the private or the general public, and even then I would still wonder how it's not against the First Amendment to not allow it. So that's my question. I know it's kind of simple. There's probably a very simple answer to this, but it just seems like to me, if there's anywhere we should allow the First Amendment to be utilized, like, courtroom photographers or, video, you would think it would be in a federal courtroom. So that's my question. Have a good day and take it easy.
Christopher, better known as Johnny Knoxville, calling us from Chapel Hill, North Carolina. Always good to hear from you, my friend. Always good to see you too. And I saw you earlier today, and I don't know if you left us before your call got answered. And it's so great. Somehow buried in the news cycle with Bryan Kohberger was the idea that Sean Combs' trial came to an end and they had a verdict on his case. So he was found guilty of 2 counts, the transportation for prostitution counts, which were the really lesser of all the counts he was facing, and found not guilty of the more serious trafficking and RICO charges. So a win for Diddy. No other way of describing it. A win for Diddy, a loss for the prosecution. But Johnny's question, or Christopher's question, is not so much about, it's just funny to me. I think this is the first Sean Combs question that we had. Big, huge news. We're all kind of like, yeah, whatever. Why are we looking at this picture? Why are we looking at this drawing? And why are we not looking at a photograph is Johnny's question. Why are there not allowed cameras in the courtroom in federal courts? And that is the reason why. It's a federal court and they don't allow cameras in the courtroom. It is funny to me. I found this out from one of the Fox News producers, that this artist who does these drawings is like the same woman who's been doing it for years in the federal courts in New York. And they were just kind of commenting on the skills of the artists have maybe skipped a step. How's a nice way of saying it? That the drawing skills sometimes leave something to be desired as far as perspective and caricature. Anyhow, that was probably unnecessary for me to comment on, but I did find it to be funny. It's the same artist for decades. Another cool thing is I've always wanted to do something in federal court just so I could purchase one of these drawings, because I always thought it was really cool when attorneys have up in their office one of these paintings from an appearance in court. Anyhow, totally not your question. Your question is, why don't we have cameras? Well, take it up with Chief Justice John Roberts. He's the one that sets the rules. It's not abusive of the First Amendment because it is an open courtroom. It is an open courtroom. You can go in there. If you can get a seat, you can go in there and watch the trial. The media has access to it. They're allowed to go in there and report on everything. It's just you're not allowed to bring cameras. Well, they've decided that the First Amendment doesn't specifically say to what extent the media should have access, just that the media should have access. But that doesn't mean that they should have access in any forum that they want. And it's up to the courts to decide what that is. So each courthouse can set their own rules. Each jurisdiction can set their own rules. And the feds have decided that there's no cameras in the courtroom, which I think is ridiculous. I agree with you. Do you know that there has only been one photograph of the Supreme Court in session ever taken? And it was by someone who snuck a camera in. Why? Why in the most important forum in our judicial branch are we not allowed to see how the sausage is made? Why can't we see these arguments taking place? What a fascinating thing, an educational thing that would be to have cameras in the courtroom while the Supreme Court is sitting, or while any federal trial is taking place. But how about the Supreme Court being able to, these hugely impactful decisions that are going to affect the rest of our lives, and all we get is audio? Let's see it. Why not? None of it makes sense to me. I don't understand the reasons for it. Certainly in this day and age. I understand we don't want to turn it into a spectacle. I understand we don't want to turn it into some sort of, event that's entertainment. But, we've got cameras in Congress. I don't think C-SPAN is lighting the world on fire. We can see what's happening in Congress. The president gives, press conferences all the time, but the one branch of our government that we're going to hide behind closed doors and no cameras is the Supreme Court. Anyhow, I agree with you, Johnny. I agree with you, Christopher. I agree with both of you. Let's change things up. Write a letter to Chief Justice Roberts. All right. Here's our last couple here.
Hi, Josh, and the Courtroom Confidential crew. So from New Zealand calling in again. Love listening to this show. I usually listen to it on Monday because you're a day behind me when I'm doing some work. So, yeah, and the show length is really good because by the end of the day, I can stop listening to your show and I've done enough work. So it's perfect length. So don't shorten it, will you? Otherwise, I'll be finishing work way too early. My question was for you. I wonder now that the cell phone evidence is being allowed in for the Stephan Stearns trial, will he do a Kohberger and perhaps take a guilty plea and not face trial on the CSAM charges? And then I also wondered maybe he may feel like taking a guilty plea on the murder charges to take the death penalty off the table. So, yeah, I was just wondering what your thoughts were on Stephan Stearns now that that cell phone evidence is coming in, and whether it might change his view about whether to proceed to trial or not, or whether going and taking a plea and taking that death penalty off the table would be something that he should think about doing.
Great point. Sue from New Zealand. Let's put New Zealand on the map. I don't think is this our first caller? No, we've had callers from New Zealand before. Yeah. Okay. But Sue, I think it's our first time hearing from you. So thank you so much. Therapist, says I'd like to hire her to read me the phone book, please. Yeah, your accent's getting a lot of you got a lot of fans here, Sue. And if you are listening to this in the future, good to see you. I hope that you've been able to get all your work done because we're getting down to the end. But great observation and great question about Stephan Stearns. Should we expect a similar situation as in Kohberger with Stephan Stearns? He is, of course, accused of horrific acts of sexual assault against Madeline Soto, 60-something counts of that, along with her murder. A beautiful, beautiful young girl who just lived a nightmarish life until she was finally killed by this monster. And he's looking at the death penalty. So do we expect maybe the same kind of resolution? I would not be shocked, Sue. Yes, and it usually comes at something like this. He's now his last chance. If you think about it, Kohberger took a plea on the heels of losing his alternate perpetrator motion. That was probably their last shot at mounting any kind of serviceable defense in that case. And I'm sure they lost that. And Taylor turned to Bryan Kohberger and said, Bryan, what do you want to do? You're looking at the death penalty and we don't got much of a case. And he says, see what you can do for me. And the same conversations might be happening with the defense team and Stephan Stearns saying, that phone's coming in. Every horrible, unthinkable, nightmarish thing you did to this beautiful girl is coming in. And the jury's just going to sit there for days watching it, hating you, before they decide to convict you of everything and put you away in prison for the rest of your life. Do you want to take a plea deal? And once you go to trial for her murder and they hear about all this stuff too as being the motive for you murdering her, they're going to want to put you to death. So what do you want to do, Stephan? So perhaps those same conversations are taking place right now. Excellent observation, Sue. Case that absolutely sickens me. I know that Gisela has been following that case very closely on Grizzly True Crime. I encourage you guys to go over there and watch her coverage of it. Just one of those cases that makes me sick. Mwanbet says, thank you, Josh, et al. Well, thank you so much for your kind and generous support. Nashe's an extraordinary machine. Became a new YouTube member. Appreciate that. Yeah, let's get all the thank yous out of the way before we get to our last question here. All right. It's that time, guys. We've reached the very end. Who is going to bring it all home for us? Round of applause.
Hi, Josh and crew and everybody watching. My name is Gisela Kay. I'm South African and I live in Switzerland. And before I ask the question, I just want to encourage everyone that if you're submitting a question and you feel like, oh crap, I need to start over again, don't worry. Me too. I've started this a few times now. Okay, so here's my question, Josh. You are an attorney and the host of Courtroom Confidential and the host of the True Crime News Sidebar podcast. And now you have a Fox News gig as well. And you're in demand, okay, on this channel called Grizzly True Crime. Okay, so how do you keep up with all of that? Firstly, how do you drink your coffee? How do you fit in a workout? You're a dad as well. I think you have 3 kids, right? What? You're a dad, you're a husband, you're doing all these things. So like, how do you keep up the energy? Because for me, like nap time is essential. So that is my question. I'm sure there are people wondering, okay, you're welcome. I asked it. And other than that, everyone have a wonderful day.
Oh, Gisela, I hope you're still here and listening. I don't know if you are, but thank you so much. This really, really touched me to hear you leave a comment. First of all, always great to hear from you. Always great to support the Grizzlies, and such kind words for you to say. The way you laid it all out does sound exhausting. I'm exhausted thinking about everything that we've got going on over here. Yes, I do have 3 little ones. Yes, I'm still working as an attorney. Hopefully not all that much longer. Thank you so much, Banella, for the congrats on the Fox position. Yeah, a lot of spinning plates over here at the Courtroom Confidential headquarters. Nap time. Big fan of nap time where I can get it. In the afternoons, I usually turn to Tiffany and, when the kids are all kind of settled and say, do you mind if I go lay down for a second, which turns into many seconds, but yeah, without kind of recharging. But at the risk of sounding overly, and there's Gisela and there's the Grizzlies, and please go give a big shout out to Gisela. Next time you watch one of her videos, please tell her the big love sent over from Courtroom Confidential to her. Yeah, at the risk of sounding cheesy and overly sentimental, I will say that the support from all of you is a huge part of what keeps us going. It is rough and it is difficult, and we are exhausted and we're working very hard. But to have the feedback and support from all of you and people like Gisela is absolute fuel. A huge shout out to all of our mods who help take some of the the pressure off us, to Sonia and Afton and Kathy. Obviously, Kaylin, huge part of making all of this possible, and a huge thank you to her. Tiffany, my wife, she's my partner in every possible way and couldn't be doing any of this without her. And our beautiful girls, I think, are my motivation more than anything else. But thank you, Gisela, for the kind words and for giving me an opportunity to thank everybody, to thank you all, and to thank everybody who's involved, either directly or indirectly, with making this adventure of ours what it is today. So that is all of the questions we're getting to this week. We've got plenty more that missed the deadline that we'll get to next week. Please continue to send them all in. Let me give you guys some quick announcements before I let you go on with the rest of your Sunday. First of all, CrimeCon. We were asked about this earlier. Are we going to be there? Yes, we are. And so are you. And to give you a reason, if you've been on the fence, to push you over and convince you to join us at CrimeCon, we called up CrimeCon and we said, we've got a lot of people who are enthusiastic about it. Can you help them out at all? And they said, yes, we'll give you a discount code. So if you enter the code courtroom, one word, all in caps, you will get 10% at discount. Something, it's a little help. It's a little motivation to, if you were still trying to decide what to do, go ahead and enter courtroom, and you'll get a discount, and it will let CrimeCon know that you're coming to support us. What you missed on Saturday, of course, we had our weekly roundup, as we always do. It was a bit of an abbreviated episode because of the holiday, but we talked about Stearns and Sean Combs and Kouri Richins and, of course, Bryan Kohberger and all the stuff that we kind of covered today, but we gave you the latest news on all of that. So that's up on the channel now. Please check it out. Then Monday, we got some really great guests for you guys this week. We are not taking any breathers here at Courtroom Confidential. On Monday, like I said, Kevin Fixler called me up and he said, "Have you seen this new video? You got to check it out." I said, "Yes, come on Monday and we'll chat about it." Kevin Fixler from the Idaho Statement. We're going to be talking about the new computer imaging of the crime from the Bryan Kohberger case that was released. That will be live this Monday, tomorrow at 5 p.m. Pacific, 8 p.m. Eastern. Check it out. Then Wednesday, finally, he was able to take the smallest amount of time off. This is one of the busiest men in news reporting, Brian Entin from News Nation. If you've been following the Kohberger case, you know that Brian has been the tip of the spear in reporting a lot of these things. Brian Entin, that man right there, is the one who broke the news that Bryan Kohberger was taking a plea deal. And we'll talk to him about that, get his reactions, talk about the aftermath. That will be on this Wednesday, again, live at 5 p.m. Pacific, 8 p.m. Eastern. So please join us to support Brian and give him a big thank you. Then, as always, you guys I know are all sitting there in anticipation as to how can I possibly join our membership program. Well, I'm going to show you right now. If you go to thecourtroomconfidential.com and click on become a member over here, you can hear about all the membership benefits of joining the crew. So please check that out. If you want to check out whatever kind of merchandise we might have. This shirt, for example. What am I wearing, Tiffany? What is this? Turquoise pina colada. What is this one called? Turquoise daiquiri. I don't know. Caitlin doesn't know. Tiffany might know. All of the colors, all of the fits, please check it out. And some of the OG stuff too. And we've got hats. Seafoam, says Diane L. Is that the name of it? I don't know. I don't know where Tiffany went. She's chasing around kids. Bunny Bella says Seafoam too. Maybe it is Seafoam. Oh, and they are super comfy, says Afton. So that's where you go if you want to buy some of the merch. These colors are very popular with everybody. And then what do you do if you want to, what am I doing here? How do I get back to the home? If you want to leave us a message, you go on, you click over here on send a voice message so that you can be a part of next Monday's shows. Next Monday's show, Sunday Fun Day. Leave us a message, click on start recording. You get 90 seconds to ask us a question. Afton says, "Thank you all for coming. Please hit the like button." Yes, please do. On your way out the door, hit the like button. What else do I got for you? Leave us a message, join the membership, buy some merch. Thank you to our mods, Afton, Sonia, and Kathy. You're all fantastic. Thank you to all of you. And thank you so much for spending another Sunday with us. And have a great weekend, everybody. Take care.